Let me just start my remarks by commending board staff for a job well done. It was an interesting assignment that was before them, and when we looked at the proposed changes to Rule 133, the underlying legal opinion, and compared it to existing statutes, the board's existing regulation, and cases, we found that board staff's proposed amendments were wholly consistent with and supported by these authorities. And don't let anybody tell you any different. With respect to case law, and this is something that the previous panel did not address, case law sets forth factors that militate for or against business inventory treatment. One of the factors articulated in case law is that relinquishment of control is sufficient for business inventory treatment. There are cases that discuss these sorts of circumstances. And don't let anybody tell you any different. An actual transfer, an actual sale in the traditional sense is not required. It's not required according to cases. It's not required under the board's existing rule, Rule 133. The second point that I wanted to address relative to case law is that when you have the purchase price of property that takes up a large part of the service that's being provided or is a large part of the overall package, that is a factor that weighs in favor of business inventory treatment. Another factor that weighs in favor of business inventory treatment is whether the property is advertised or displayed. Another factor that weighs in favor of business inventory treatment is how the taxpayer is treating the property for financial accounting purposes and for federal and state income tax purposes. I'm not here to litigate the SpaceX case, unlike the previous panel. There will be an appropriate time and an appropriate place to do that, and that is not here, and that is not today. What I can tell you is that the factors that are articulated in the cases support business inventory treatment for SpaceX, and I'm familiar with SpaceX's facts, but I suspect, as Mr. Vinatieri will confirm, probably for the rest of the space transportation industry. Okay? The other thing I wanted to commend staff on, very important point, which is the uniqueness of the space transportation industry. Just because circumstances are unique does not mean that the board does not have authority to regulate that. Were that the case, the same county that was before you lobbying heavily for the passage of Rule 474 would not have succeeded in their efforts. The board clearly has authority to do this. The unique nature of the space transportation industry and the federal regulatory overlay is an important fact that board staff picked up on, drilled down on, and made its proposed regulatory amendments based on. That was a very important consideration, and board staff should be commended for that. I'll just conclude my remarks with saying that we strongly urge this board to adopt the proposed amendments that staff has put before you and to move this regulatory process forward. Thank you.